I've been asked quite a few questions about the trial over the Chris Kaba shooting, because there appears to be quite a lot of confusion and misunderstanding over some issues. So what I want to talk about is, why wasn't manslaughter left to the jury? What might happen with any future disciplinary proceedings? And the issue about releasing the officer's name and making that public. So first of all, to start with, where it comes to self-defence or defence of another, it is for the prosecution to prove to the requisite standard, in other words, so that you are sure beyond reasonable doubt that the use of force was not unlawful, in other words, was not in self-defence or defence of another. The test for self-defence, it's a two-part test, or defence of another. The first part is subjective, the second part is objective. So what do I mean by that? Well, first of all, you look at what was the threat that the defendant honestly, even if mistakenly, believed it to be. So that's a subjective test. So the test is, what did the person actually think was happening and what the threat was? Then it moves on to, once you've established that, what would a reasonable ordinary person do facing that threat? And that element is objective. It's not what the person thought was an appropriate response, it's what would a reasonable person think was an appropriate response. But here you see, the actual issue of the use of force was not in, that wasn't actually an issue. So what's what we call the mens rea? What's the mens rea for murder? The mens rea for murder is that you intend to inflict either death or serious harm, as a consequence of which somebody then dies. But in this particular case, there's no issue that obviously there was an intention to cause serious harm, at least, because obviously shooting somebody will cause them serious harm. So when it comes to self-defense, defense of another, it's all or nothing. It's either murder or acquittal. There is no middle ground. Sometimes manslaughter is included as an alternative to murder, but that's usually where it's, what is the intent? I didn't mean to inflict serious harm or death. I just meant to inflict some harm. I mean, the classic example is what we call the one-punch manslaughter cases. Somebody punches somebody, they fall over, crack their skull on the pavement, and subsequently die. In that particular case, the issue will be, well, did you intend to commit serious harm, or do we accept you didn't intend to commit serious harm, in which case that negates it to manslaughter. There can also be issues around things like diminished responsibility. Yes, I inflicted this injury, but at the time, I was suffering such adverse, state of mind that I wasn't fully responsible for my actions. But again, that wasn't an issue. So in this particular case, they didn't leave manslaughter to the jury. And indeed, there was no grounds for that, because neither party, neither the prosecution or defence, were arguing for circumstances that amounted to manslaughter. And as a general rule, you don't leave compromise cases like that, because there's always a danger that a jury, that's having a hard time deciding, they might go, well, we'll just compromise and we'll just call it this. It had to be 12 people, or at least a majority, 10 one way or the other, guilty or innocent. And in this particular case, they found not guilty. But that's why it's not it's not manslaughter. But what about the disciplinary proceedings? Well, the interesting thing there is the test for self-defence, use of force, is different. In civil law, both elements are objective. It's not what did you honestly believe, it's what did you reasonably believe. There's still grounds for it to be a mistaken belief, but it has to be a belief that was reasonable to hold. Okay? So it's not the subjective, it's not what did he think, it's what would somebody else in that situation think. But they actually now, they use the civil standard, the civil test, in police disciplinary proceedings. So it's a much lower threshold to effectively convict, in quotes, somebody, because it's not, what did he say, it's what would we have done. But of course you do take into account, the courts recognise that all use of force self-defence issues, they're quite often, you've got to think in the split second. I mean, one quote Oliver Wendell Holmes said, no man is totally rational in the face of an upturned knife. And they allow, that to be taken into account. And what the English court says, the best evidence as to, what was reasonable in the circumstances, what was somebody thinking, is what did they instinctively do? I mean, it's strange that in self-defense use of force, you're often better saying, I actually just reacted on autopilot, I reacted instinctively, rather than saying, well, I thought about this and I assessed the situation. But of course, officers, they are taught to sort of make these split-second decisions. I mean, just to declare an interest here, I have lectured to the police, including the firearms police, on use of force. So they are very, very well aware of these issues. But obviously that might be something that comes into, any disciplinary proceedings. Like I say, it'll be a lower threshold. What about the decision? Well, first of all, the two things here. You may have seen now that information about Mr. Kaba has been released. But at the time, there was a prohibition on releasing that information in the public domain because they didn't want the jury accidentally reading it and taking that into account. But why wasn't it relevant to the case? Well, when assessing the situation, you base it on looking at the evidence. What did the person know at the time? And it was accepted that at the time they didn't know who was driving the car. They knew the car had been involved in other firearms offences, but they didn't know who was using the car. So Mr. Kaba's background was irrelevant to any assessment of the threat. So that's why it wasn't admissible in evidence, because it's the situation as you knew it, not the situation as it subsequently turned out to be. It's, you can only plead your case on the information you had at hand at the specific time, not what comes to light later. So that's why that wasn't admissible at court. And the reason the judge put a prohibition on that is because, presumably, even when juries get all the warnings about only decide this case on the evidence that you hear in court, not on what you hear outside court or anything you read or anything you see online, that's why there was the prohibition there. But the judge did lift that after the trial. But what about the identity of the police officer? Well, that was done at the behest of the family. Originally, the officer was just identified as NX121. And that's not uncommon in situations where people are facing death threats, defendants. And it's not just police officers. The general starting point is that justice should be transparent and defendants are named. But we've seen in cases, it's like, going back to all the days of the Mary Bell case and Maxine Carr. They know that quite often, and in the Maxine Carr case, she was actually convicted of being an accessory to murder, but they knew afterwards, they say, all right, because of the death threats to her, we have to give her a new identity and relocate her. Now, obviously, with a police officer, it's a lot harder to do that. So the argument was, well, unless and until he is convicted, we should not name him. But there was pressure from the family that they said they wanted his name out there so people could know about this. And, the argument is, well, people might come forward by naming defendants and people might come forward and say, well, I've got some evidence about this, I know something about this, although that would probably be difficult to apply in this particular case. But that's why he was named. Now, obviously, is there anything he can do about that? Because he's suffering from death threats. And it's very difficult because you can't really bring a claim against a judge for a judicial act. They have absolute immunity. So, you can't claim against the court service or claim against the judge or anything like that. However, there might be a European Convention on Human Rights challenge under Article 2, the right to life. Now, even the European Court has made it very clear that, generally speaking, the police and the legal system owe no duty of care to potential victims of crime. So the mere fact he's saying, I am a potential victim now because there's a contract out on me, so, well, tough. It's only in very limited circumstances, like the police have been found to owe duty of care, and that is when they have specifically told somebody to take a particular course of action. Somebody's reported, that they are in danger, and the police have said, do this, do that, do something else, and as a result of that advice, the person has come to harm. But other than that, the police, you can report and say there's somebody stalking me, there's somebody coming to, get me. The police don't actually even have to turn up if they don't want to. However, there was a case called Osman, which argued where that was a civilian, but they had faced death threats, reported them to the police didn't take them seriously, and the person subsequently, did come to harm. Now, in that particular case, what the ECHR, the European Court, said was, although in this particular case we don't find the police were in breach of their duty, an absolute prohibition, a blanket ban on duty of care is incompatible with Article 2, the right to life. So it may be that the officer would have a challenge, an ECHR challenge to say, by naming me or by having this policy of naming defendants who, in cases like this, who are subject to death threats, that is a breach of my Article 2 rights, my right to life. So it'd be interesting to see what happens there. But yeah, the other thing that came up as well was the jury apparently had written a note. So they delivered their verdict and they actually had written a note that they wanted to be read out in court. And the judge said, no, he's not allowed that. So now there may be ways we can get access to that note. You can't generally do anything that reveals discussions in the jury room, but it may be that, the note can be released. I actually had a case myself once, many moons ago. It was one of these sting operations by the fake sheikh at the News of the World, Mazhar Mahmood, who himself ended up in prison. But it was effectively, it was entrapment, which actually isn't against the law. Entrapment isn't a defence in English law. But he'd gone beyond that. It was like an agent provocateur thing. He had effectively said to our clients, he'd pretend to be a sheikh, said, I've got this big deal for your company, and it was all done. But then before he signed the contract, said, let's celebrate signing the contract. Let's get partying. And it's like, can you sort us some drugs out? And it was like, well, no, we can't. All right, well, deal's off then if you're going to be all stuffy about it. And in the end, they knew somebody. They rang a friend. The friend came, brought some drugs. And of course, this was all surreptitiously filmed. But interestingly, in that particular case, the jury came back and said, we have only convicted these people because, Judge, you have told us that they have no defence in law. You've effectively directed us to convict. But if it was up to us, we would have acquitted. And as a result of that, even though it didn't have to, the judge said, bear in mind what the jury have said, I will take the unusual step of actually suspending these sentences. So there you go, quite a lot of things to look at. I mean, if anything else occurs or crops up or you want more detail about this, feel free to ask in the comments. But as always, hope you found that vaguely interesting, vaguely useful. And I think actually this particular time, that was more than vaguely accurate.